first time, we have closed captioning
Yeah.
appearing on Zoom screens.
Yep.
Do
Very
we see the
exciting.
closed captioning? Because I
I
don't
don't
see
see
it.
it.
right now. You do
Yeah.
see it?
I don't see it.
Well,
Where do you see
maybe-
it?
Maybe I have to
It's
change.
down
my
on,
view.
down on the bottom of my screen.
You can change your settings if you'd like to see it or if you'd like not to see it. To
You
change your
know, I don't want to see it, though. I have to say, I love it on television because it's hard for me to hear,
Yeah.
and so I turn the TV up so loud, like my mother used to do when she watched Fox News. It drove me crazy. But so now with the closed caption, I kind of understand things. And we had a bill, I think, and I don't know if it came to our committee, where some senior citizens groups were asking that all movie theaters be required to have closed captioning on the films at the commercial theaters so that they could better hear or could better understand what's going on in the movies, which I'm becoming more and more sympathetic to. Anyhow, you recall that we had Chip Triano in about 2 weeks ago or 3 weeks ago
Yep.
to walk us through the House version of H-157, and then got put on hold because the bill went to rules and we didn't know whether our committee would get it or perhaps another committee, but we now have it. My understanding is there's not too many changes from what this committee passed in an omnibus housing bill a couple of years ago. One
Two.
significant change is I think we passed out the threshold that governs a bunch of things at jobs of $1,000. The Senate ultimately raised that to $2,000, and the House has now raised it to $3,500. So that's
Yep.
going to be one area of concern, but I'm hoping that the rest of the discussion will track pretty closely to what we already passed. So with that, I don't know if David Hall is with us.
He is.
Okay,
I mean, he's
David,
there. He is magic.
David, were you the counsel on this bill when we passed it 2 years ago?
Yes, sir.
Okay, can you walk us through what the House did and fairly quickly, and if you could focus on where you see, if you can remember where you see differences from the bill that was 2 years ago? I don't think there are major changes, but maybe you can identify. If you can't, we have other witnesses that I'm sure can, like Lauren and Chris. So, but if we could start with you, that would be great.
Yeah, they wipe my memory and reset me every session. So
That's
honestly,
okay. Okay,
I
that's
don't
okay.
really remember.
Okay, if you can remember any, that's fine. But if you can't, just walk us through the bill quickly, and we'll all have to collectively, have our memories rejogged.
I have my floor speech handy.
Great. Well, that will help. Are you seeing H-157 as passed by the House?
Yep.
Great. David Hall, Legislative Counsel. I'm going to skip over the findings, though at some point you'll want to visit those because they do speak to some of the perspective of why this bill is happening.
Okay.
Then section 2, remember, this is adding residential contractors to the long list of professions that are subject to the jurisdiction of OPR. I believe that used to be subdivision 48 in the original version, and since then we've added a couple of new professions to the roster. So this is magic number 50. Then we add a new chapter in Title 26. This is where all the different professions have their chapters and the provisions that are specific to them. Remember that this bill, as you passed it, requires registration.
Right.
It does not require licensure. It does not have ongoing continuing education requirements, etc. It is designed to create a list and a registration process and some minimum requirements. And that is the result of the Sunrise report that said registration would be the most appropriate path forward for residential contractors.
Could you get to Nathan, or I'll ask Lauren, who's on the call, to make sure that we post the sunrise report?
Oh, right. Good point.
Send it to Nathan right now.
Okay, thank you.
So as you noted, Mr. Chair, in 5501 here, the registration requirement is triggered when what's prior to contracting with a homeowner to perform residential construction in exchange for consideration more than $3,500, including labor and materials. There's a definition of residential construction. It is intentionally broad. It means all of these things: build, demolish, alter residential dwelling unit, or a building or premises with 4 or fewer residential dwelling units. It includes interior, exterior construction, renovation, repair, painting, paving, roofing, all that stuff. So there are, of course, also exemptions. So remember that requirement, $3,500 direct contract between residential homeowner and contractor. So not subs, but between the homeowner and the person performing work. But we do have these exemptions: employees acting within the scope of their employment, people who are already licensed or regulated, like engineers, architects, plumbers, electricians, delivery of consumer appliances, AV equipment, etc., landscaping, work on a structure that is not attached to a residential building, or work that would require registration but is performed in an emergency, provided you register soon thereafter. So 5503, the whole purpose here is to say we have registration, which is mandatory. We will also offer voluntary certifications, which you don't have to sign up for, but you can if you want to. For instance, if they adopt the standards for certification for, green X, Y, and Z, or tiling, or whatever, there could be certifications and you are allowed to sign up for those. This piece, all pretty standard fare, tells the director to administer the registry and sign people up and maintain a list and collect the fees. As with most professions, there are advisors who help guide the office with regulation of this industry. In this case, it would be 2 people in the field who are registered, have 3 years of experience, and are active in the profession. The fees are as follows: registration of an individual, $75. If you're a business organization, it's $250. And then the certifications, if those come online, would be $75 for a first and $25 for a subsequent.
So those are unchanged from our proposal.
Very the same. So eligibility, you basically have to be in good standing in compliance with the provisions of this. You can't have any outstanding judgments against you related to professional services to homeowners. And then there are the requirements, which should look familiar to you. The first one is liability insurance, $300 per claim, $1 million aggregate. You remember the writing requirement, so that if you're registered, if the job is for $3,500 or more, it needs a written contract. The contract has to include a price, which is either a max price for all work and materials, a time and materials statement not to exceed a max price, or time and materials and no max price. But you have to specify one of those things: work date, scope of work, change order. So how do we amend the contract? What do we do? And then
testimony right now.
you'll see under 3 here, amendments do have to be in a writing as well.
Sorry, David, can somebody mute? There's somebody who's typing away and talking in the background that you can hear it.
He's muted now.
So if everybody could mute, that would be great. If you're not, David.
Yeah, unfortunately, that may be the sound of my clicking cursor, but I'll try to do it a different way. It'll be a little more jerky.
I don't think so. It was faster than your cursor could
Okay.
go all these pages.
All right, so the last piece is the down payment requirement. So this was modified slightly on the House side in a floor amendment to clarify that under 1 here, if you do specify a max price for working materials, you may require a down payment of up to 1/2 of the contract price for the price of materials, whichever is greater. And then 2, if it specifies it's on a time and materials basis and there's no max price, then the contract can require a down payment as negotiated by the parties. And that was the clarification made on the House floor to make sure to say that we can still have a down payment if there's no max price, but it's just going to be whatever the parties decide it is. Prohibitions and remedies. So there's a little bit of a change here from the House side to just to narrow the scope of the enforcement so that you'll see an A here, it's the civil penalty. So no opportunity for criminal penalties, which would otherwise be available to OPR in an enforcement action, just the civil penalty for unauthorized practice in A. The sort of B is discipline for unprofessional conduct, except that there's the substantive standards concerning quality of work do not apply because, again, this is not licensure, it's registration. And then we have some specific examples of what it means to have unprofessional conduct in this context. So failing to have a written contract, liability or workers' comp, consumer protection violations, false claims of certification, fraudulently obtaining licenses, etc. There's a sort of a.
Could you just go back to the beginning of that section? I missed what you said. This exception that
Yep.
129AB does not apply to a registrant.
Sure.
That's quality of work. Is that what you said?
Right. So in the scope of licensure and the regulation of licensed professions, they could bring an enforcement action against you because the quality of your work is below the standard of the industry, basically. Poor workmanship. And that is not applicable to this profession because they are not regulating quality of work in any way. They are just registering you and imposing these minimum requirements. So because we're grafting this, layering this onto the construct of OPR's administrative authority for professions, we have to take that piece out, 129AB.
Okay. And just to refresh my memory, you think in the bill previously, in terms of our registration, we had the same civil penalty for people who don't register when we're asking them to?
Well, you do have the same civil penalty, but the Senate version and the version up until the House floor has just been basically the standard enforcement and regulatory framework applies to this profession as with all others. And that does include the possibility of civil, criminal, and administrative enforcement. And the House floor, there was quite a stink raised about somebody who doesn't register is going to become a criminal. So an amendment was offered on the floor to basically say an A here that it's only the civil penalty that's applicable. You would not have criminal enforcement.
Which,
Okay, so we'll get back to that. And curious as to, what the AG thinks of that. I mean, we want, in the least possible way, we want to regulate or register these folks, but we certainly want to make sure that we have some teeth here. So we'll have to talk about that some more. Go ahead.
Fair enough. So wrapping up here, implementation, there's a initial biennial registration beginning next April. You can start receiving applications in December. You get an early bird special, and 3, if you register early, they'll reduce the fee. There is no enforcement before April 1st, 2023 for unauthorized practice and failure to register. And then in B here, on or before July 1st, 22, it says OPR will establish an initial set of voluntary certifications to include at minimum OSHA standards on construction projects and components of green building. I pointed out on the other side, nobody cared, but the statute is discretionary in that they don't actually have to set up the certifications, but then this says that they do. So that's July 1st of 2022.
Can you say that again? Where's the inconsistency?
Well, the underlying statute that we're creating says that OPR may establish certification programs. It doesn't require them to do so. But then subsection B here in the session law says that on or before July 1st of next year, they shall set up an initial set of voluntary certifications. And that has to include at minimum OSHA standards and also green building standards.
So we have to fix that. Okay.
Section 5, so it does authorize a new position in licensing and a new position in enforcement. There's an FY22 $200,000 appropriation, but this is a quirky thing from the appropriations committee. It's not actually moving general funds to OPR, but it's just authorizing them to spend part of their monies, which they call special funds, to fund these positions. So note that this is not a general fund appropriation, but it does require authorizing language from the legislature according to House appropriations.
But
Okay.
that's consistent with what we do when we've had this with other Secretary of State positions, right? I mean, I recall that we've had to authorize them even if we don't fund them.
Yes, usually the legislature does authorize
Right.
positions, and it was just novel to me to see this term special funds and have it be.
Oh, yeah, well, we can.
Doesn't matter. I think, I trust that they know what they're talking about. The last piece, the status report, January 15th of 23, tell us how it's going, the number of people involved, resources, the complaints, the enforcements, the resolutions, and any other issues. This will take effect on July 1st.
Does this bill, I think the bill we passed had a requirement for the Secretary of State or someone to develop simple model contracts for people to use?
Yes, we did.
I don't know that this requires it, but I know that they are doing it.
So it's not in the bill at this point. Okay.
Right.
No, but it would be good because it was one of the criticisms we got last 2 years ago was,
Yep.
oh,
Yep.
this is going to be such a burden. Right.
Right. Okay, good. Well, thank you very much.
Sure.
Any questions for David? Okay.
And just on that special fund, I have as a note here that actually we include that it was, I said both positions are funded entirely out of OPR's special fund raised through fees, and there are no general fund dollars. So, I mean, I guess we must have used 2 years ago the term special fund.
Yeah, Lauren could fill us in. We'll get to her. Let's move on to,
Let me ask you a question.
sure, absolutely.
There's nothing in here, is there, or unless I've missed it, that provides for any increased costs for investigation or other activities other than what the Office of Professional Regulation does. I know that they haven't investigated. There's nothing for the Attorney General for or anyone else outside of OPR, is there?
No.
In other words, the question comes to mind of, well, who investigates what? And is that something that OPR is going to do under this bill?
So Chris Curtis is our next witness, and we'll hear from him, and we'll also hear from Lauren from OPR.
Okay.
I remember that, I think in significant part, the Attorney General brought us this issue and this bill, and they were having trouble finding and enforcing some of this stuff.
Right.
They wanted the bill, and I don't think they ever asked for more resources to do what's in their general scope. Just these cases are falling through the
Right.
cracks. So we'll hear from Chris.
As we go forward, and I know that when we hear from the witnesses, we presumably will get answer to that. But my underlying question is, if we pass this, what's going to change?
That's a
And
good question.
how are
I-
Going to
yeah,
be better
yeah.
protected than they are
I
right
think
now.
I think there's an answer to that. It
Okay.
may not be perfect, but I think the situation will be greatly improved. And I think our witnesses, both Chris Curtis and Lauren, and their Sunrise report can tell us, what is being missed and how this will make things better. But that is the key question.
That's
So,
the nub of the matter.
okay. So, Chris, are you with us? I can't see everybody.
Yep, he's there.
Okay.
I'm here, Mr. Chair.
Chris, welcome. Good to see you again.
Nice to see you too. I hope your allergies are resolved quickly.
Yeah.
Mr. Chair, members of the committee, for the record, my name is Christopher Curtis. I'm the Chief of the Public Protection Division at the Office of the Attorney General. Within public protection, we have 2 units, our Consumer Protection Antitrust Unit and our Civil Rights Unit. I'm here today to speak to the former and our duties with respect to consumer protection. Every year, our office receives thousands of calls from concerned Vermonters about any number of issues that may confront them. One of the perennial complaints that we receive and attempt to assist consumers with are complaints about home improvement contractors. And I want to be clear that the range of complaints really can be from disputes about quality of work all the way to potentially criminal conduct, et cetera. My office is responsible for civil enforcement. That's enforcement of our Consumer Protection Act. And I want to thank this committee and your sister committees in the House and the chambers that have really taken, I think, a balanced approach and have spent an unusual amount of time and resources over the last few years to really dive into this issue and try to come up with what in my judgment is a fairly reasonable, light touch regulatory approach for a really important cornerstone profession in our state. Is a hugely important part of our economy. And I will say, from a consumer standpoint, a person's home is probably the single largest, most important investment that they may make. So this is critically important, I think, to the contracting community as well. There's a recognition that this is really important. And my experience with our friends at the Office of Professional Regulation, who undertook a Sunrise review of this matter a couple of years ago, was that both the contractors and homeowners were very engaged and very interested to come up with a solution that might work for all and really improve things. So I'm just very pleased that there's been a lot of time and effort put into this issue. By way of background and context, I can share with you that over the last 2 years, 2019 and 2020, our Consumer Assistance Program received nearly 200 complaints about home improvement contractors, and that was roughly about $2 million in alleged losses. And I say alleged losses because these are complaints from the consumer. And there's a process through which we endeavor to hear from both sides and all parties and work to resolve these kinds of complaints. Sometimes those issues work out and there's a resolution that's favorable or satisfactory to the parties. Other times it doesn't. Still other times it may result that the complaint that we're hearing is really a criminal allegation, a criminal complaint. And so those might be referred to a state's attorney, for example, for further enforcement actions or follow-up. But I think fundamentally what you all as policymakers have been grappling with is that there is no home in state government, no single home in state government for this range of complaints. Even our Consumer Assistance Program, which receives hundreds of these complaints, not everybody knows about. So not all the complaints are coming to the Attorney General's office. Some are going to state's attorneys. Some are going to local law enforcement based in a particular community. Others may call the Secretary of State, having heard about the Office of Professional Regulation, but currently there's no handle for that office.
You forgot about us.
And certainly people call their lawmakers, absolutely.
Oh, definitely.
So there's a wide range of possibilities, and I think it can be a little confusing to homeowners about sort of where in state government to go. And what is interesting and helpful about the bill that is before you is that this would really create one central intake point for these kinds of complaints. That does not mean that our office would cease to take an interest in this area or would cease to seek to attempt consumers that contact the Consumer Assistance Program, but it does mean that there would be, outside of a judicial process, because even if we act on a complaint in a consumer protection matter, or if it's referred to law enforcement for follow-up, we're likely looking at judicial process, which can be time and resource extensive in terms of trying to reach resolution. But the bill before you is somewhat novel and interesting in that it would provide an administrative process through which to resolve these complaints. And the teeth that are here are that if a contractor is really failing to honor its obligations or duties, then the state of Vermont, through the Office of Professional Regulation and through a proper adjudication where all the parties are heard and there's due process and so on and so forth, would have the ability to revoke the registered entity from practice. And so that would be a signal to the broader community and to consumers everywhere that this is perhaps an actor that's problematic until they can get back into compliance. So that is a somewhat more
Can I ask a
elegant
question
and
on that?
efficient
Can I interrupt?
solution. Yes.
And this may be a question more for Lauren. So you're saying the enforcement tool at the Secretary of State could revoke their registration? Does that mean that if they continue to practice without being registered, they can be, what happens to them at that point?
That's a great question, and I will certainly be happy to hear about OPR's perspective on that. From our perspective, I think if there was an actor whose registration was revoked and they continue to practice, there's on one side of the equation, there's perhaps OPR's authority to pursue someone for unauthorized practice in that profession. From our perspective, that would likely be a Consumer Protection Act violation because they're not registered essentially to be doing business. And so holding themselves out as a legitimate actor at that point when they're not supposed to be because they have been they've had their registration revoked would present a fairly simple case, I think, of unfair or deceptive practices.
Okay, that could be a less time-consuming, straightforward enforcement tool, as opposed to the facts of the case or individual facts of a contract. If somebody's just practicing without being registered or having been revoked. Okay, let's keep going. I'm sorry.
That's all right. So the bill before you really builds on the work that this committee did on S-163. The Senate passed a couple of years ago. And I will note that I mentioned that these kinds of complaints that we receive are perennial. We receive them every year. I think a couple of years ago when we were before your committee, we produced a 5-year report, a 5-year look back from 2012 to 2017. There were approximately 600 complaints at that time over that period of time. Again, a little more than a couple of $1 million in alleged losses. So my point is only to underscore the fact that the issues are not going away. You can look at the spreadsheet we provided your committee and you'll see that many of these cases do resolve. That's great. That's ultimately what we want, is to convene the parties and try to work out a satisfactory resolution. In some cases they don't, or they need to be referred. But I think that what you have before you is an administrative body that will have more participation because there's more consequence for the parties and there's more inducement to want to participate in that resolution process. And I'll defer to our sister agency to talk more about that. I did want to talk briefly about the threshold, the $3,500 threshold for a written contract amount and or for registration. I think it's good that the numbers are consistent. At various times over the years, sometimes those numbers have been bifurcated, but our position has always been that in terms of helping the public and the regulated community understand what the threshold is, it would be best to have those numbers be the same. So that was a good modification that the House made. At various times they were different numbers. But I did want to note that of the roughly 288 complaints we had in the 2-year period that you all have before you in our spreadsheet, and I can send that to Nathan so he can post that if he hasn't already. About 60% of those were for dollar values or alleged losses that were less than $3,500. So let me say that again, about 60%, more than half of the complaints were for less than $3,500. So in the past, I think your committee has attempted to try to cast a bit of a wider net to ensure that there are more of the complaints are captured and might be remedied by this type of process. So I just wanted to flag that for your attention, and so you can consider sort of.
Would you be able to, I mean, I guess somebody can do the math, but could you break down, come up with a similar percentage at 2,000 and 2,500 and 3,000? See if that changes the percentage at all?
Yeah, last
Certainly.
2 years ago, the range, the biggest number had been between 1,000 and 7,500, as I recall. But there were
Now,
lots that were lower.
the irony in the offline conversations I've had with the chair of the House, I did readily admit when I heard that the number was higher that the price of these contracts has probably changed quite a bit with the price of lumber. I'm doing a deck now and it's crazy, so what was $2,000 2 years ago may be much higher this year. So
Yeah, but
So-
it'll also go down post-pandemic, hopefully.
right, hopefully.
So we would be happy to assist the committee to look at to work with those numbers to get you the percentages of sort of where the line falls in terms of the majority of complaints and that sort of thing.
If you can get that to us sooner than later, that would be better. Because we need to move this bill along and it may have to go to 2 other committees.
I'll be sure to do that today.
Okay, great.
I did want to, I'm happy to, I want to make sure plenty of time for the other witnesses that you have today. And I just want to make clear, we are supportive of this effort. We support the bill. I did want to flag a couple of other things that I just noted while your legislative counsel was doing the walkthrough. One was in the down payment section. There's that clause that for a contract where there's no maximum price, the down payment may be negotiated by the parties. And I wasn't sure, and maybe your legislative counsel can clarify whether that also means that the down payment itself, the agreement between the parties that's negotiated, would be reduced to a writing or included in the contract. It seems to me that part of what you're attempting to do is make sure that there's a clear understanding between all the parties about what the terms and conditions are. And that's why you have the written contract requirement. So for a down payment that's being negotiated, I would think that policymakers would want to avoid confusion about an oral negotiation that took place about the down payment, but that wasn't reduced to a writing so that it actually is confirmed by the parties. So you might want to think about just making sure, I think it's implied that that would likely be part of a contract, but it's not necessarily expressed in that provision. And because it's a separate provision, I just wanted to flag it for your consideration. You might want to just really lock that down, make sure it's clear that yes, you can negotiate, but then put it in writing. So everybody, there's no after the fact dispute about, what was said or what was promised. So that was one piece. And then somebody asked a question, it might've been you, Mr. Chair, but I can't recall, about the criminal versus civil penalties for failure to register. I think it's very common for registration, whether it's your simple business registration at the Secretary of State's office or other forms of registration, that a penalty associated with the failure to essentially file the paperwork is a civil penalty. So I don't think we hadn't previously considered it, and we didn't have a formal position on this, but I would say it's broadly consistent with Vermont practice and policy, that a simple failure to file, an omission, if you will, would result in a civil penalty, as opposed to a criminal process. And that seems to me to be appropriate in this instance, where you're really trying to do a light touch regulatory framework. I mean, I suppose if after a couple of years, the legislature, and you have a report that'll be coming to you. So I suppose if it turned out that, well, everybody was just going to treat this as a scofflaw and nobody wanted to register, then it might be something where you want to revisit down the road and say, how could we, beef this up to ensure it? But I think that most actors are good, legitimate small business persons or even large business persons, and they want to comply with the law. My sense has been and would be that people want to do the right thing. Most Vermonters want to do the right thing. And because this is a very modest effort, sort of a toe in the water rather than a cannonball, if you will, I think that most people will be happy to avail themselves of the resources of the state, whether by simply downloading a very simple paper contract that might be provided for them by the state, sign up, tell us who you are and where you work, make sure you've got your insurance, and kind of move on with their lives. So I think I'd be very surprised if there was not robust participation in a program like this.
Do you, getting back to the two questions on the level, the $3,500. I guess I'm concerned that it would only cover 40% of the complaints, but I also wonder, just establishing this program that even at a higher level over time would start sweeping in a lot of people just by common practice. Do you share that, your complaints may go down even though there is these small jobs, there may be issues, but that these home contractors, they're gonna have jobs over 3,500, and then I have jobs under 3,500. And to the extent they have to register for the jobs over 3,500, they're registered. To the extent that they're using contracts and their form contracts, they may use them for their smaller jobs as well.
It's hard to speculate. I suspect that's likely to happen, just because it would become sort of the accepted industry practice and just be easier to be consistent. I could imagine business owners, even small business owners, where maybe it's a primary contractor and with one employee, just basically saying, yeah, if we've got a written contract, it's as to one as to all. So it's the same for our big jobs as it is for our small jobs.
Okay. So the other question related to this is, what does your research show? My recollection is we're sort of an outlier compared to other states, both in terms of not having any regulation whatsoever over this profession or this sector, and also what we're proposing in terms of a threshold.
It's a great question and a great point. I think that Vermont is an outlier, which is unusual because typically with our consumer protection laws, Vermont is often a leader. In this particular instance, there's been very little state oversight, if you will. It goes back to my earlier point. There's no home and state government for the contractors. And so this would bring Vermont more into line with the vast majority of other states. And Ms. Hibbert may recall the exact number, but there have been studies done that have canvassed that landscape. And I think it's an overwhelming number of states that have not just required registration, but often licensure or certification. So much higher standards in the industry with, in some cases, I think in Massachusetts, there's a 2-day exam that you have to take in order to measure up, and you got to pass in order to be able to practice in that state. So very different. In fact, during the Sunrise review, we actually heard from some practitioners, some contractors who operate in Southern Vermont. They said, well, we work in Massachusetts too, and I've already got to do all of this work in order to be able to apply my skills there. So in some ways, I'm over prepared for what Vermont has to offer. So this would be catching up. And I remember there was an old, I think it was, I can't remember, maybe I found it through the National Council on State Legislatures or others, but there was a national report that looked at the various sort of regulatory overview of this profession. And there were at least 37 states, as I recall. I'm just going off the top of my head, so please don't hold me to it. I can try to dig that up for you. But I think at least 37 jurisdictions had much stronger regulatory regimes, and only a very small handful had, absolutely nothing. And that's really what Vermont is dealing with right now.
2 years ago, there were 23 states that licensed or registered and 10 that had registries. So I was also interested in an update on that because my guess is that figure has changed, but 33 states either license or register.
So, my guess is that not certainly the states that have licensure or certification or whatever probably don't get into this issue of the size of the job, but I'm wondering if they're among the states that sort of distinguish between small jobs and big jobs, whether there's any threshold out there. I seem to remember that some states had a threshold, they had like a job of $100 or more. But so I don't know, maybe in the Sunrise report or Lauren knows that, but if before next week you can see if you can find any answers to that question, Chris, that would be helpful.
I will see what I can find on that. And also just recall that there is there may be a sort of different thresholds in terms of, I know some states had dollar values that were associated when a written contract is required. Sorry about my dog.
My dog is now very confused. So.
And also the threshold at which one might be registered, licensed, or certified to practice. So again, other states may treat that a little differently. I think one thing that's good about where Vermont appears to be moving is just making sure that those thresholds are at least consistent.
Okay. So before we let you go, I think Senator Brock's question is at the heart of the matter. Could you summarize an answer to his question as to why doing this, in addition to centralizing it, in terms of enforcement, why things would change?
It's a simple answer. There would be one place to report all allegations of potential misconduct, and there would be an administrative process rather than a judicial process. And I think part of our hope is that in the end, this would save everybody time and resources and money. And that's whether you're the contractor or whether you're the aggrieved homeowner, because currently now the only remedy is the sort of whack-a-mole approach to where you report, and then hoping that if there's an enforcement action, it's actually going to result in some kind of judicial resolution. Our CAP program can only do so much to help the parties try to reach resolution, but they actually don't have a mechanism through which to compel the parties to come to the table. So I think the administrative remedy here in terms of bringing the parties to the table and also ensuring that the revocation of a registration, which would then, if you're not going to participate and you're a bad actor and you just say, fine, come and get me, well, now you're in the unlicensed practice of the profession. Now it's a much simpler case for a prosecutor to bring if they had to, if you continue the bad conduct, and you're no longer registered. So any consumer can go to the Secretary of State's website and see that you've had your registration revoked. That is a big red flag. And that's apart from the current home improvement fraud registry, which we do have and which is promoted on our website. That requires a criminal conviction. So that is a much higher standard, a much higher burden, as opposed to the party who simply says, I don't care what the consumer has to say. At this point, I'm going to walk away and you try and come and get me. I think having a home and state government for oversight with an advisory board, which might be made up of experts in the field or a combination of experts and consumers, would be very compelling and would be an elegant solution to the problem. It's not going to be a panacea. It doesn't solve all the problems, but it does provide one more tool in the toolbox that I believe will resolve many of these kinds of complaints.
So if I had to sum up what you said, I understand the idea of one home. That's helpful to the consumer. And also, I guess I see what your consumer assistance program is doing now in terms of trying to resolve the dispute between the parties is something that the investigators at OPR would similarly do, but they have the power to say in the end to take a meaningful action if the parties can't reach agreement, whereas you're left with probably only the most egregious cases being brought for some sort of enforcement mechanism. So you're probably, trying to bring the parties together in a lot of these cases, but then telling a lot of the consumers there's not much we can do here. Right?
Unfortunately, with the CAP process, that may be the result. And then the question is, does it get referred to central office? And then the question is this a civil complaint or is it a criminal complaint? Because if somebody is actually alleging fraud, the Public Protection Division, we pursue civil enforcement. So then it's got to get referred to another prosecutor.
Right.
It's very frustrating to the consumers to be sort of bounced around, state government in that fashion. So
in a criminal case, the law enforcement can do something about it, but it's obviously it's a judicial process. You could bring a consumer fraud complaint, but that has, I guess you're not bringing many of those in these contexts. As a consumer,
any civil process is going to be time and resource intensive.
Right.
So
Okay.
that's a little different, and certainly a criminal case maybe as well. So
I got it. Senator Brock, is that? Do you want to follow up on that, or I think I'll ask the same question of Lauren, but I think
I would as well.
Yeah,
Question,
okay.
of course, is if this passes, what, if anything, are you going to do differently?
Well, I think a lot of the enforcement is going to move over to OPR.
Well, I understand that, but I'm asking really from the standpoint of the Attorney General's Consumer Protection Office. Is there anything that you're going to do differently?
yeah, we will still, of course, have our consumer assistance program. And I think that for many of the complaints, consumers can be referred to the Office of Professional Regulation to register those complaints and to see if OPR's oversight can get those resolved. If in fact, and I'll let Lauren more talk about their process and how they'll handle those kinds of claims, that doesn't mean that ultimately there might not be a referral by OPR for either a criminal complaint or a Consumer Protection Act violation. So in that respect, we still have those powers and we would still pursue those matters if they're referred to us.
How would we measure whether or not this has been successful and that things have improved?
I think you'll do that through the report that is contained in the bill. You'll get an assessment after a period of time to show the number of matters that were brought, the number of resolutions. And I think, one thing is, I mentioned earlier that there's a sort of a wide variety of, kinds of problems that arise from, allegations of poor work performance on the quality side to, somebody took my deposit and never showed up to do the work, an outright theft. And so my hope and expectation is that with a more standard approach to where consumers can go to make their complaints, and with an administrative remedy that is efficient for all the parties, that there can be faster resolution of these problems, and that we will actually see, with some uniformity and some transparency and accountability for the profession, that we will actually see many of these kinds of issues subside. One thing I can tell you for sure is that we hear anecdotally, and we heard during the Sunrise sessions, that very often there are problems between the parties about what the agreement actually was. Vermont has long relied on the handshake deal, but that is a recipe for consumer dissatisfaction, and frankly, dissatisfaction on the part of the contractor when in fact a dispute arises after the fact, because there is no writing that has recorded what the terms of the agreement actually were. So one of the things you have before you, in addition to whatever process is set through by the state, you're going to have something where the parties at the outset know specifically what was agreed to, what were the terms, how much was supposed to be paid. And in the end, if it's the homeowner that's being unreasonable, the contractor has some protection from liability, because they say, no, here's the written contract. This is what we all agreed to. So if you're asking me for more now and you're not willing to do a change order, or I can't buy the materials to do the extra work you're asking me to do, I have some protection because that wasn't part of our original deal. So I do think that this is both a good form of consumer protection. It's also a good form of liability protection for the contractors.
Thank you.
Okay, thank you, Chris. Lauren.
Good morning.
Good
Lauren
morning.
Hibbert. Good morning. Lauren Hibbert, Director of the Office of Professional Regulation. I'll do my best to not repeat all of what Chris just said, although a lot of our talking points were the same for this committee. So I really wanted to address what we did in our Sunrise process. I think there's some members of the public or this committee that may not understand the very important role of the Sunrise process in Vermont. It's housed in Chapter 57. And when requested, we are required to do a thorough analysis of whether there is a public harm that requires occupational licensure, registration, or certification. And we are mandated under the law to choose the least restrictive form of occupational regulation. And that really comes from the very libertarian concept that is baked into Chapter 57, which states that any occupational regulation is an inherent restriction on the marketplace activity and should be only utilized by the state when it's absolutely necessary. So we were asked to conduct a Sunrise of home contractors. We filed that Sunrise report in 2017. I was able to send it to Nathan. It is posted on the website. What we found, we of course coordinated and worked very collaboratively with Chris Curtis's unit over at the AGOs. And we found that 61% of the complaints were for projects under $5,000. We had a public comment email. We also had several public meetings. And what we heard from homeowners is that the available civil and criminal tools are really insufficient to protect Vermont homeowners when a project goes wrong. That it's possible to get small claims judgments and restitution orders, but they're easier to obtain than they are to enforce. And that's a flaw in small claims court. There's not a way to compel somebody to pay you after you have that judgment or restitution order. We also found that Vermont is one of 8 states that doesn't license, register, or certify home contractors. States do this activity in different ways. Some do it at the county level and some do it at the state level. What we found in our report is that Vermont does not have a strong enough county system to do it at the county level. We found that in some counties and some cities, there's a more robust permitting process. but that's not happening uniformly throughout the state, and there's wide variation. So with that, we did find that there was public harm, that it exists in this field, and that we found that a mandatory registration, which is our lightest touch of occupational regulation in the state, would protect the public. And we also found that unfortunately, the elderly and disabled Vermonters are often most targeted for home improvement scams. So with that, we've been supporting S163 and now H157, which is a light touch registration for home contractors. Oh, I just also wanted to add that after we filed the Sunrise report, we also went on a talking tour with the AGO's office. We went to Springfield, Burlington, and Newport, and held public meetings to talk about the findings of the report and our proposal under S163. Again, that was in the January of 2018, I believe. The principles of this bill are very minimal. Again, liability insurance, registration, if the job is over 3,500. Mr. Chairman, you have pointed out that is a raise since the last bill that this committee reviewed. It has been, in my understanding, it really has been driven by the cost of materials. I think this is an area that the committee could dig into if they chose to, either reducing the threshold or if I had an elegant solution, I would have proposed it already, but I think there is, I'm committed to continuing to think about it, but I think there is a possibility to separate labor from materials in this contract price, because labor is more static and materials are more fluid with the market. I haven't come up with an elegant way to say it. I've typed it about 50 times, but it just doesn't, it's not easy to explain. So 3,500 is easy to explain, and anything else that I've come up with is harder to explain.
Based on your Sunrise report and what you know about this, are you comfortable with 3,500, or do you think it should be higher or lower?
I think it should be lower. I testified in the House that it should be lower. I think that the House made some, when it came out of the Committee of Jurisdiction, it was at 2,500. I supported 2,500, but then it went through subsequent committees in the House and was raised. I think it was a series of negotiations. I think that if this committee keeps it at 3,500, we will still be protecting the public. We will still be providing, public protection. And I think a subject of the report could be, when we're reviewing the complaints for the legislature, whether that threshold is appropriate, whether we're receiving complaints at a lower number. But I did testify on the House side that I thought it should be lower. And continued to do that even as they raised it.
Do you think the reporting I don't have the bill in front of me right now, but the reporting section that's in the bill, I assume that's a report to be done by you?
It is.
Do you think you have the authority within that language to look at that and make a recommendation back within the report, or we need to change the language?
I can just have one moment. I'm just going to look at the reporting language. I do think that I have the authority to look at that, because if you look at section 6, sub number 3, I am supposed to report back to you the number and nature of any complaints or enforcement actions. So if I have a large volume of complaints that are under the threshold, that would be part of what I would be reporting back to.
Okay. I'm sorry I interrupted you.
Oh, that's okay. I see that Senator Round has a question.
I don't have that up.
Oh, okay. Sorry, I'll interject.
Go ahead.
Thanks, Mr. Chair. Lauren, I don't have the bill in front of me either. I could pull it up, but it occurs to me that $2,500 is the amount sort of to the value of the work that was proposed, right? And that you have an estimate for. I mean, I really do feel like we should lower the threshold again, because someone could be doing a small project and cause a lot more damage than that in, so we're not even talking about the amount of money that you might have in damages from a very small project. Right? Is that right? We're just talking about the value of the original agreed upon project. And by the way, I love my contractor. We have a great relationship, and he's asked me to help him write his contract. So I do hope we put some samples in the.
The Office of Professional Regulation is working on a sample contract, and I'm hoping to just do some final touches on it and submit it to this committee for your review. We haven't been able to provide that up to this point, but I think it would be helpful. I just want to make sure that the AGO's office also agrees with what we're proposing. So we will have a sample contract, hopefully for this committee this session. And certainly we will have one as if we regulate this profession, we will have a sample contract on our website. Looping back to a separate question earlier, that is not a requirement of the bill. And that would be something that the committee could add if you would like to.
Yeah, we required it last time.
I believe that you did, but it is not a requirement of this bill this time. Senator Rum, yes, the threshold requirement is the scope of work contracted for, not the potential damages if it goes awry or is done incorrectly.
No way you can estimate that.
That is correct.
I just want to let you know that we need to move along. So if you have more things.
Sure, I'll go as quickly as possible. So this is very light touch. Again, insurance, if the job is over $3,500 and a written contract, we will provide one. There are benefits to the master roster. Currently, there's no master list operating in the state. This was a question that came up consistently during COVID, particularly. We helped ACCD and the administration get out information to occupations, and we were asked if there was a home contractor list. There is not one. It would be helpful to have one. There's also no standard process for determining or adjudicating construction fraud complaints. They can be done at the local level, they can be done at the AGO level, they can be done in civil court, but there's no consistent path. And then, as I said, COVID really escalated the need. And then without a master list, it's very hard for training opportunities to be widely dispersed to everybody who may be in the field. So we know that training opportunities are sometimes done on word of mouth because we don't have a master list. I do think a master list solves some of the problems of word of mouth. Some of Senator Brock's questions about what is going to be changed and what the burden will be on OPR. We will administratively house these complaints, and there will be due process. I don't think it's going to be a small lift for OPR. That's why there are two positions in the bill. Although the administrative process is in some ways more streamlined than the civil process or the criminal process, there is still a lot of due process. There is an investigation, there's a formal set of charges, there is a hearing, and then there are subsequent appeal rights. So before we are able to take any disciplinary action on a licensee, there's a lot of due process that happens. And then once there is an action taken against a licensee or registrant in this case, it would be noticed publicly, the public would be able to see. And as a reminder for this committee, we have the power to warn, reprimand, condition, suspend, or revoke a registration. So there's a lot of discretion and appropriateness built into the disciplinary process to make sure that it's finely tailored to remediate the harm that was created or to protect the public. So If there's a small,
Lauren, can I interrupt for a second? Because it's um, sort of, I'm hopeful. I'm a believer in mediation, and the disciplinary word is necessary. I understand that, but prior to getting into the disciplinary frame of mind, if you get a complaint, do you have the ability to talk to both parties? And I would assume that a large percentage of things can just get resolved and go away by virtually having a third party in the middle facilitating a conversation.
so we absolutely talk to both sides of during the course of an investigation. If there's mitigation to be done, that's where we would refer the case to the CAPS program at the AGO's office. We are really not a mediator agency. We are identifying if a standard of unprofessional.
Mediation means different things to different people. I'm not, talking about putting parties in two separate rooms and having someone shuttle back and forth like lawyers do in mediation. I'm just talking about you get a complaint. Is there any preliminary discussions that go on? Because I think sometimes there's just a lot of misunderstandings that could resolve the matter if they know that you're there and you potentially will have a disciplinary action, and you just want the parties to talk. I mean, what I guess my question is you get a complaint from a consumer, what's your next step? Do you immediately go into investigation, or do you try and get the parties to talk to each other first?
We typically go into investigation. I'm trying to think of similar professions where we have complaints. I think dentures is an area, so dental examiners. There's quite a bit of concern around dentures and misunderstanding about what they're going to do and how much they cost. And what we find is we have the same investigatory approach. We talk to the complainant and we talk to the respondent. And sometimes in the course of that investigation, the parties talk to each other and resolve the case financially between the two of them. And then our sole question remaining is, did that dentist act in an unprofessional manner? And frequently the answer is no. So I would imagine that that type of engagement would happen again, but no, we would not have our investigators meet with both parties at the same time and talk out the issue. That would be a substantial lift for our office that we have not contemplated and we have not done previously in other professions.
Okay. So I don't know if Chris Curtis is still on the call, but
Still here. And that is we literally call our process at the Consumer Assistance Program letter mediation. So we receive a complaint and I expect that, to the extent that we continue to receive complaints from consumers, we would probably treat it much the same way, and that it would start with a letter mediation process. And it's only where that process is unavailing that we would then suggest to the consumer that they can refer their complaint to the Office of Professional Regulation if this bill should become law. So that would allow the parties that time to have this sort of informal resolution process. You'll see on the spreadsheet we provided, there are a number of these that just get resolved, as you correctly point out, Senator. It just requires somebody to sort of step in and say, what was the problem? If the parties are both being reasonable, very often they can reach some kind of accord, and then the matter is just disposed of. But I think in those instances where there's really no other remedy or relief, having that administrative body that can have a more formal process to really engage the parties and find out the facts would be very helpful.
And I think we would do the reverse, which is we would be starting to look at our complaints and see what would be appropriate to refer to the CAPS program. So
that's important. I don't want to lose that piece. It sounds like the direction of Chris's testimony and your testimony, it's all going to you. And if it's going to you for investigation before there's an opportunity to even see if the parties want to talk, that would be a big loss in this whole process. So I hope
I don't want you to think that that's my testimony. I think that what we'll do is we will look at these complaints and see whether mediation is appropriate. And there may be both conversations happening at the same time. There may be a dual process.
Okay. All right, let's move on because I have like 4 more witnesses in 15 minutes.
Okay, I'm sorry. I'll make myself very quick. So I think the areas that the committee should engage on is the threshold number. And then I'll just say that I have had conversations with Matt Coda about who's included and how. I want to make sure that the committee really considers if you exempt whole classes of people, currently there are ramifications. So currently, a large number of Mr. Coda's constituency is registered with public safety. That is an express exemption, and I think it's appropriate. But in conversations post-House, he and I have talked about, and I think we're going to work together to come up with some ideas. But if you are licensed by DPS and you're employed by a business, that business is not licensed by DPS. So should the business be registered with OPR? Or if you are an electrician, but you're not licensed, but you just provide electrical services on a single family home, you're not required to be licensed in that instance. If that is true, should you be required to be licensed with OPR? So there's some large policy conversations around who must be.
Let's just take that one as an example because I'm not sure. I want to be sure I understand it. So if you have an unlicensed electrician, which is allowed if they're doing small jobs, I guess, does the House Pass version consider them a home contractor where they have to be registered?
Yes.
So what's the problem?
There's no problem, but just if you start to exempt electrical, I think it's a fine needle to thread because, and I don't want to speak.
I know the House has exempted some groups.
Yes.
You have a problem with those exemptions right now?
No, I do not. But I just know that there will be.
You're anticipating other people asking for an exemption.
And Matt and Coda and I have talked about it, and I anticipate that will be an issue that this committee will want to talk about. And I don't want to speak for Mr. Coda, but I think that there's a very fine, a small eye of a needle that we need to thread here because we want to make sure that we're being intentional about who we exclude. And
we can, after we hear from Matt, we can have you back in and we can figure it out if you guys can't figure it out. Okay.
Okay. Thank you very much for your time.
Thank you. I'm sorry to rush you. Lauren, I have one more question for you.
Yes.
And Randy has a question too.
Okay, I'll get to Randy. Thank you, because I don't have the pictures up. We haven't heard really any anecdotal stories of problems in this area, but I assume there are a bunch of horror stories. I mean, I remember some woman writing me from Essex that $50,000 was taken from her and the person never returned to do the job.
Right.
Well, we don't have so at some point I want to hear those. I guess now is not the best time, but I'm sure you have some of those from your Sunrise report, and Chris probably has some too. Okay, let's move on.
Let me ask a question.
Senator Brock, I'm sorry, I don't have the picture up. Go ahead.
Lauren, can you tell us about the cost and availability of insurance?
Yes. The cost of insurance depends on the type of work you're doing and how many people you employ, and the cost. So if you're a single person doing handy person work and you only ever work by yourself, then the cost is somewhere between $500 to $700 per year. And then it goes up from there. Obviously, if you're a roofing company employing 10 or 15 people, it's much higher. What we've heard is that the majority of home contractors do have liability insurance.
Could a contractor structure his or her job so that they never do a job more than $2,500, although they may do more than one job in the same general area for the same person sequentially? Could someone, in other words, structure so that they could avoid this entirely?
Yes, absolutely, they could. They could do 10 jobs at contracts that were $2,000 each and intentionally avoid the intent of this law. They could do that.
Okay, thank you.
Okay, anybody else? I know I don't have my pictures up, so
I'll help you on that. Nobody at the moment.
thank you.
But we have 3 people who've been incredibly patient.
Okay, so let's hear from Mr. Talbot first.
Brad Talbot, you're muted.
Yeah, I just clicked it on. Can you hear me?
Yeah.
Okay, this has been a very interesting conversation you folks have been having, and I'm relishing it myself. It's been a long time since they've had any direction towards having some sort of construction control with respect to perhaps making sure there's professional people doing the professional work.
Brad, could you identify yourself and?
Oh, I'm Brad. I'm the principal for the Vermont Licensed Plumbers Association.
Okay,
We are a subscription membership of close to 400 people.
Okay.
Who are all licensed plumbers.
Okay.
And I also, through the use of that office, provide continuing education.
Yeah.
For license renewal.
Right.
And for a long time, I've had my plumbing license here since 1977 in Vermont. So I'm also a licensed plumber, and I'm also certified in gas and oil and electrical. So as I was beginning to say, I was quite surprised when I first started reading the bill itself, because at the beginning it said that the reason for that was to set up a framework for registered construction contractors. And then when we get further into the bill, is nothing about commercial. It's mostly residential that's talking about. I can give you some anecdotal evidence with respect to the plumbing trade and the kind of things that happen when people are taken over the barrel, so to speak. Most of the time, these people end up letting the thing go because they have to go through what's called the civil case, and civil court is backed up. And if you're talking about a $5,000 or an $8,000 bill that is involved in that they're fighting over, most of the time the homeowner bites the bullet and has the work repaired, because it costs almost $8,000 to repair the mess up. So you can repair it and then wait 3 years or something like that, not even get recompense as it is. So obviously we do need to do something about that. The thing that occurs to me is that you're listing a whole bunch of various types of work that go on in a residential household. It's not just the residential building structure. I just sat back and right off the top of my head, I came up with, well, what about interior decoration, insulation, masonry, windows, sheetrock, overhead doors, roof gutters, well drilling. There's quite a few things all involved doing that may not be under the residential contractor's control. The homeowner might be doing another contract for somebody to do the overhead door. They might be doing another contract for somebody to do something else. And the actual residential contractor himself may have a subcontractor who might be making enough money to register himself as somebody in this naughty or nice list. It looks like that's going to be put up on the board for people to look at.
So Brad, are you saying that the way you read the bill, that a lot of those vocations and work are not covered by the bill?
No, well, they're not specified in the bill. And it's been my experience over time in that as long as you don't specify it, then it leaves that area open for debate, in which case you may not get a resolution out of the thing that you would like to have.
Okay.
And I hate to see
I-
something go in there that's kind of,
Okay,
up in the air.
I think that's certainly not the intent, and
Oh,
we'll look at it closely to make
And
sure
Brad,
that.
some of those people are licensed in other capacities with OPR. So OPR licensed some of that list that you have just listed.
Right, because I'm familiar with licensing, having an apprenticeship, and
Right.
training and tests, and not just working with somebody who learned how to do it from his dad. And then that call yourself that, it's not like you just slap something on the side of your truck that says contractor. I'd like to see people that have actual training in contracting before they do that. I think that would go a long way, along with this bill, would go a long way to mitigating some of the circumstances you have with people who are getting taken over the barrel, so to speak.
Yep.
Now, the one thing that I find in here is that you're going to try to duplicate the actual services that are being provided by licensing. Now, a Department of Fire, DSF, I believe, Fire and Safety, DFS, they have the programs for the electrical and for the plumbing, and there's a couple other apprenticeable trades that they are working with.
Right.
And I think after talking with Matt about that, I was concerned in here in that there is an exemption for plumbing and electrical, etc. But the paragraph above does not have an exemption for the words, and it includes these following words: the installation or repair of heating, plumbing, solar, electrical, water, or wastewater systems. And all of these systems right here are licensing. These are licensed and are run by various departments. And the other ones are not. The painters, the carpenters, there's no licensing requirement for them. And I don't like to have us, who always take our tests, we go through our classes, renew our licenses, we pay our fees, etc. We do have inspectors who come and look at our work. And if there's a problem, the inspectors write up administrative penalties. So there is an enforcement issue here.
Right.
And we would be removing a goodly amount of people from this if we took those words out. But let's see, there would be approximately 1,800 plumbers. There would be approximately 3,000 electrical workers. There would be specialists, which are gas, HVAC. So we'd be up into the 5,000 or 6,000 people who would be taken off of that list. But that would leave something wide open for these people who are working with the Office of Professional Regulation. There's only a couple of them, and they're going to have to do the whole state. Are they going to find these people who aren't, I mean, drive up to a job, the guy's doing contracting, he's not listed in the list. So what are we going to do with that guy? And how about somebody coming from out of state, doing some work, then going back? Are they going to register with the state? Is there going to be enforcement if they don't? And I think that by maybe cutting out those 5,000 people and all those certified and licensed people who are already being controlled by the department, and leaving the remaining amount, it would be better enforcement because there'll be less for these people to worry about. They'll be able to go and they'll be able to do, I think, a better job. It's going to be a tough road to hoe for them to run this here in the state of Vermont. It's not going to be easy, and especially when you start getting into a naughty list and a nice list, and there's going to be people saying, well, that wasn't right for him to do that. There might be lawsuits. There might be some sort of stuff involved with that. And then there's the fact that we've found in the plumbing trade.
Brad, I hate to interrupt you, but you're very articulate in making your point. I know you'd like us to do more, in terms of getting at this problem and do it in a more efficient way, we'll consider that. I'd like to get one more witness in, if I could,
Yeah.
before the next 5 minutes.
Mr. Chair, we have 3 minutes before we're on the floor.
Okay,
Okay, well, thank you for your time.
thank you, Brad.
Thank you very much.
Chris, I know Matt could come back. Chris, can you?
Yeah, I can absolutely come back. Just let me know when and I'll make myself available.
Okay, I think we're taking it up again on Tuesday morning.
We apologize. It's all.
I am absolutely happy with the process. I loved what I heard. You guys are really being very thoughtful, and listening to it is heartening.
Good.
So I appreciate even just being able to listen in.
Good. We usually don't get those compliments. We appreciate it. Okay, committee, we'll see you all on the floor. Thank you for the witnesses, and we'll pick this up. Matt, I apologize. We'll see you, but you know the drill, and we'll see you
Thank
next
you,
Tuesday.
Matt.
Have a
Thank
good
you,
weekend,
Brad.
everybody.